Hello, friends. Good evening. Let's start our discussion for today. But before that, let's quickly discuss what we saw yesterday. Yesterday, we spoke about counteroffer and we learnt an important rule, which is that a counteroffer rejects the original offer. Let's quickly revise the example that we saw yesterday. A offers to sell his bike to B at rupees 50,000. B says, I will buy it at rupees 40,000. So B makes a counter offer. The effect of this counter offer is that A's original offer is rejected. However, let's say A agrees. A agrees to the price that B is offering, which is rupees 40,000. So A agrees to sell his bike to B at rupees 40,000. Question is this an agreement between A and B? And if so, then who is the offerer and who is the offeree? Let's apply the concept that we just discussed and we learnt about it yesterday also, that counter offer rejects the original offer. So the moment B made this counter offer to A, it means that A's offer is rejected. So A is not the offerer then. A is not the offerer then because his offer is automatically rejected by B's counter offer. It mean and the second thing is B is making a counter offer, which is accepted by A. So doesn't it look like the situation has reversed? Which means that if you pay close attention, it looks like now B is making an offer. Counter offer becomes an offer made by B. And the acceptance of that counter offer is by A, which means that A becomes the offeree. So the situation reverses. Initially, we started with A being the offerer and B being the offeree. Now we have B as the offerer and A as the offeree. So in short, the effect of counter offer is, yesterday we saw one effect, which was counter offer rejects the original offer. Today we have seen the second effect, which is that person making the counter offer becomes the offerer. Earlier he was an offeree, now he becomes an offerer. And the original offerer, the person who had made the first offer, becomes the offeree. So in a counter offer situation, the role is reversed. And when a counter offer is accepted, by the original offerer, who now becomes an offeree. The contract slash agreement arises only on the terms of the counter offer and not on the original offer. Why? Because the original offer is rejected the moment a counter offer is made. Okay, so keep this also in your mind when you're dealing with a counter offer situation. Now I'll give you one fact scenario which I want you to think about and analyze, and we will look at the answer tomorrow. So the fact is, NLSIU makes an offer to a student A. Offer says, you are selected for the BALLB course. Admission fee is rupees 5 lakh. You must pay the fee within 7 days, failing which your seat will be forfeited. You will lose your seat. After receiving this offer, A sends an email to NLSIU and asks, can the fee be deposited in cash? Now, NLSIU's offer does not mention the manner in which fee has to be paid. So A asks this question, can I deposit the fee in cash? And A sends this email within the 7-day window. So NLSIU gave A 7 days to accept the offer. Within this 7-day window, A sends the email asking for this clarification. NLSIU, what they do is, NLSIU treats this inquiry as a counter offer. So NLSIU withdraws the original offer and gives the seat to somebody else, and gives the seat to someone else during the same 7-day window. After he learns about this, he files a case. A files a suit against NLSIU. Saying that A had 7 days to accept NLSIU's offer, but NLSIU gave away A's seat to someone else during the 7-day window. NLSIU's response is the moment A made an inquiry about the manner of deposition of fee, A made a counter offer. So NLSIU is saying that this inquiry was a counter offer. And since a counter offer automatically rejects the original offer, NLSIU was no longer bound. NLSIU was no longer bound by the original offer. Question is, will A succeed? Think about it, analyze it, and we are going to discuss this tomorrow. Let's come to today's topic, which is communication of acceptance. Till now, we saw that an acceptance needs to be absolute and unqualified. Today, we are going to discuss how is an acceptance communicated. And why is there a need to communicate acceptance? You must be remembering this, that an agreement is offer plus agreement, offer plus acceptance. It means that acceptance is a must. And therefore, the law says that acceptance must be communicated to the offerer. This is the basic rule. Acceptance must be communicated to the offerer. There is one exception which we are going to discuss today. Now let's look at two scenarios. One where communication of acceptance by the offeree is mandatory. And second, where communication of acceptance is not mandatory. I just told you that the basic rule says that acceptance must be communicated. So you must be thinking, how is this relevant then? Which says that in certain scenarios, communication of acceptance is not mandatory. Now think about our previous classes. We saw a couple of scenarios, especially in this kind of situation where somebody makes a general offer. Lost kid case. We had seen that there was an advertisement saying, anyone who finds my missing son and brings him back to me will get 500 rupees. Now in this case, the advertisement itself makes it clear that the only thing that is required from the offeree is performance of the condition. The offeree was not required or supposed to communicate his acceptance to the offerer, which is what happens in a general offer kind of situation. In a general offer, where an offer is made to the world or to the public at large, all that is required is performance of the conditions of the offer. The offeree need not communicate his acceptance to the offerer. So therefore, we have two categories here in communication of acceptance. The second category being scenarios where communication of acceptance is not mandatory. So this is a small subset within this. So therefore I started the discussion regarding communication with the second set. Except this scenario. So let's look at one more scenario. One is a general offer, or second, even if there is a specific offer made to a specific person, the offeror may do away with the requirement of so even in a specific offer, the offerer may say that the offeree need not communicate his or her acceptance to the offerer, and the offeree simply needs to fulfill the terms of the offer. Okay? So these are the two scenarios where where communication of acceptance is not mandatory. Except these two, in all the scenarios, communication of acceptance by the offeree to the offerer is a mandatory condition. Okay, and we'll look at these scenarios closely and carefully. If you remember, when we were discussing the offer series, we had discussed that. Let's start our discussion with the help of an example. A offers to sell his pen to B at rupees 10. A thinks in his mind that okay, I will buy this pen at rupees 10. I'm okay with the price. But B does not communicate his acceptance to A. Question was whether there was a valid agreement. And we had seen that there was no valid agreement because B had not communicated his acceptance to A. B had kept his acceptance only in his mind. And he never communicated this explicitly or even by his conduct to A, which tells us that an agreement does not come into existence just because someone mentally decides to accept an offer. It means that mere intention to accept or mere silence by the offeree is not a valid acceptance. There must be some external expression of acceptance. Which brings us to the fact that, okay, we understand that communication needs to be, acceptance needs to be communicated by the offeree to the offerer. So this leads us to the question, how can acceptance be communicated? While we will look at the mode of communication of acceptance in the next class in detail. But for now, just keep this in mind that acceptance can be communicated in three ways. Number one, by spoken words, which means verbally. Number two, by written words, which means in writing. And number three, by conduct, which means through the actions of the offeree. If you remember, when we were discussing invitation to an offer, I had told you that in an auction, when the hammer falls, that itself is acceptance. How was acceptance communicated in that case? There was no spoken words, there were no spoken words, there were no written words. But in that case, the acceptance was communicated by conduct. This fall of the hammer was the conduct through which acceptance was communicated. No words were needed in that scenario. And we will look at a few more examples of how acceptance is communicated by conduct. Spoken words or written words, that is very easy to understand. Somebody, take the pen example. A offers to sell his pen to B. B says, yes, I will buy this pen at rupees 10. That is acceptance by, that is a verbal acceptance. When you have given your acceptance in spoken words. Or B could also give his acceptance in writing. B could write it on a piece of paper that I'm okay with buying your pen at rupees 10. So that is acceptance in writing. But the most problematic and the most confusing scenario is when acceptance is given by conduct, because then it becomes subjective, and courts have to find out whether there is a valid acceptance or not, because acceptance, when it is communicated by conduct, is subjective, unlike when acceptance is given in spoken words or written words, which is objective in nature. Therefore, we'll look at a few examples of how acceptance is given by conduct. There's a famous case, and we'll start with that. In this case, there are two parties, A and B. A used to supply coal, 50 kgs of coal per month to B at a fixed price. B requests A to supply 100 kgs of coal instead of 50. B wants 100 kgs of coal per month. A is fine with it, but A says that so A proposes to B, let's have a written agreement for this. Initially, when A was supplying coal to B, there was no written agreement. Now that the quantity is going to increase, A sees a risk for himself, and therefore he proposes to B that I would like to have a written agreement for the new arrangement. B is okay with it. So A drafts an agreement, signs it, and sends it to B. However, what happens thereafter is that B keeps the agreement in his drawer. and does not sign it. So B does not sign the agreement, and B also never approves the agreement. Despite this, A starts supplying 100 kgs of coal per month to B, and B pays accordingly to A. In spite of the fact that B never signed the written agreement and he never approved the written agreement, B continued to accept, B started accepting 100 kgs of coal, and he paid A for those 100 kgs of coal. Okay. So what happens after a few months is that in a particular month, A decides not to supply 100 kgs of coal to B. When A does that, B sues A for breach of agreement. A says, A's pleading is that B never signed the written agreement, nor did B ever approve the agreement. So how can there be a valid agreement? This was the issue before the court. Was there a valid acceptance even though B did not sign or give any formal approval to the agreement? The court said that while keeping the agreement in a drawer is not acceptance, and also the fact that B never communicated the acceptance to A implies that there was no acceptance. So court said two things. Number one, court looked at two things. One was that keeping the agreement in a drawer is no acceptance. Similarly, not communicating the acceptance to A also suggests that there was no acceptance by B. But the court said, wait, hold on. Let's look at one more element, which is coal was supplied on new terms and payment was also made by B on new terms. Now, what does it show? It shows that there was clearly an acceptance by conduct. And we saw before that, and we saw just before this example, that an acceptance could be communicated by conduct as well. So therefore the court said this is a valid acceptance. Okay, we will look at one more example of when there could be an acceptance by conduct. Let's say you see an online coaching institute advertising a batch for CLAT. And there's a pay now button. You click on that button and you make the payment. Payment is accepted by the coaching institute. However, the institute does not send a confirmation that you have been enrolled for the batch. Question is there an acceptance by the coaching institute? We have to look at three things. Number one, did the coaching institute communicate its acceptance in writing? The answer is, so when we discussed that acceptance could be communicated in any of the following three ways. Number one, in writing. Number two, verbally. Number C, by conduct. So apply this here. Did the coaching institute communicate its acceptance in writing? No. Coaching institute never wrote to you saying that you have been enrolled for the batch. Did the coaching institute communicate its acceptance verbally? No. They never called you. They never spoke any word about enrollment for this particular batch. Now the last thing is communication of the acceptance by conduct. Do you think there is an acceptance by conduct in this scenario? The answer is yes. How? Because the institute accepted your payment and kept the money. This shows that the institute accepted your offer. There is an acceptance by conduct. And if you remember, when we were discussing invitation to an offer, we had seen an almost similar example when I was telling you about Flipkart, Amazon. An item is displayed on Flipkart and you want to purchase that item. The fact that it is displayed on Flipkart by a seller, that is invitation to an offer. The seller is inviting third parties to make an offer. And if you want to purchase that item, you click on that item, you make the payment. When you made the payment, that is an offer from your side to the seller, expressing the fact that you want to purchase that particular item. If the payment is accepted by the seller, it means that there is an acceptance by the seller. So we had seen this example, and today we are talking about an almost similar example. If the coaching institute accepts your payment and keeps the money with them, then we can conclusively say that the institute has accepted your offer by conduct, not in writing, not verbally, but by conduct. However, there's one exception. Let's say coaching institute if the coaching institute had clearly said in their terms and conditions. So whenever you purchase any any online batch, a lot of times, most of the times, you will see that there are certain terms and conditions. Now let's say one of the terms is that payment does not guarantee admission. Confirmation will be sent after review. Okay, if the coaching institute had said that in their TNCs, then merely because you made the payment and they accepted it doesn't mean that there is an acceptance by conduct. So it will depend on the terms and conditions. Okay, but if there was no such terms and conditions, and if they had accepted your payment and kept the money, then it would have been an example of acceptance by conduct. Okay, so we saw two things today vis-a-vis communication of acceptance. One is where communication of acceptance is mandatory, which is the case in almost all the scenarios, and the only exception is this, when communication of acceptance is not mandatory, which happens in the case of a general offer, or even in a specific offer when the offerer himself tells the offeree that you do not need to convey your acceptance to me, and you only need to perform the terms of the offer. That is it. Okay, and let me finish today's class by giving you an example of this, because general offer, all of us have seen, have discussed about it a number of times, but this scenario can confuse you. So let me end the discussion by giving an example. We discussed one fact scenario where NLSIU had made an offer to A, saying that you have been selected for this course and you can enroll by making the payment in 7 days. In this scenario, all that A does not need to go and specifically communicate to NLSIU that I accept your offer. A merely needs to make the payment. So in this scenario also, there is no mandatory requirement to communicate the acceptance to the offerer. Okay, in the next class, we'll talk more about communication of acceptance, because there are a couple of there are a couple more important things, like communication of acceptance should always come from the offeree himself and not from a third party. And second is, the communication of acceptance by the offeree should be made to the offerer only and not to a stranger. Okay, so we'll talk about these two scenarios in detail today, and I would like you to think about this case that we had discussed and answer in comments whether A will succeed against NLSIU or not. Okay, so let's meet tomorrow and discuss it and the other things vis-a-vis communication of acceptance. Thank you so much. Good night.